So let's get started. I'm Kat. I'm from ERCS. I'm here with a couple of colleagues from ERCS who are supporting this evening. We've got Pam and we've got Nikki. So thank you to you two. And then most importantly, we've got Claire Simons, who is the partner in these webinars, Planning Democracy. And Claire will be talking to us about her manifesto. And so will Benji. I'll introduce them properly in a bit. But I just wanted to say that this is coming at a really exciting time. We're just about to enter what's called the pre-election period, which is when government isn't allowed to make any announcements, and the MSPs stop being representatives in the Parliament and start campaigning. So, this is a good time for us to be talking about what we want to change in the planning system, in environmental justice, and how we think we can best make that change. So I hope by the end of today, we'll have some really good thoughts on what we want to change and also some thoughts on how we think we can start to go about making that change. So to start with, I'm going to introduce you to Benji. You must know Benji Brown, some of you. He is a policy and advocacy officer at the Environmental Rights Centre Scotland, and he leads on their parliamentary advocacy in strengthening environmental rights and increasing access to environmental justice. So we're really delighted that he's going to talk to us a bit about some of the things that ERCS are campaigning on this election and also in the longer term. So over to you, Benji.
Thanks very much, Kat, for the introduction. Just bear with me one moment while I share my screen. Can everybody see that okay? Okay, fantastic. So yeah, thanks to Kat who did a very good overview of my job. But I lead on policy and advocacy at the Environmental Rights Centre for Scotland, focusing on um, policy and law reform to improve our environmental laws and environmental governance across Scotland. And I'm just gonna briefly outline what I'm hoping to cover in my presentation, and then I'll go into a bit more detail about who ERCS are and what we do. So I wanted to just touch briefly on the key concepts about what we're talking about when we're speaking of environmental justice. And I think judging by the audience here and some of the comments in the chat about where people are from, people will be very familiar with this. So I won't spend too much time on this, but I think it's helpful just to give a bit of a framework in terms of the work that we're doing. I'm going to talk about some of the routes to legal remedy for the substantive environmental problems that we have in Scotland and some of the different mechanisms that we have within Scotland to seek redress for environmental harm and exposure to environmental harm. I'm going to talk about some of the outstanding barriers to accessing environmental justice and using the court system to hold public bodies and polluters to account. And I'm going to conclude by talking about what you're probably most interested in, what actually needs to change within our current legal framework to guarantee full access to environmental justice for everyone living in Scotland, and specifically what policy changes we need political parties to commit to at the next election. So, our vision at the Environmental Rights Centre is of a Scotland where every person's right to live in a healthy environment is respected, protected, and fulfilled. We do this through four principal ways. So we're an environmental law charity, and there's four principal strands of the work that we're doing. Firstly, awareness raising of legal rights and remedies to support equitable participation in environmental decision making. Secondly, advice and representation to promote access to justice and hold public bodies and polluters to account. So we have a free advice service to individuals and community groups who can come to us from anywhere in Scotland, seeking advice on how to sound the alarm if there's a particular concern within their community. That might be to do with planning and land use. It might be to do with pollution or exposure to environmental hazards. And we'll support them to find the best mechanism to challenge that through the political and legal system that we have. Um, Thirdly, we undertake policy and advocacy and policy and law reform to improve environmental law in Scotland, and that's what I lead on in my role. focusing on the Scottish Parliament and devolved environmental policy in Scotland. And finally, we undertake strategic litigation to strengthen the rule of law, and that's something that we're hoping to do more of in the coming years. So we've just formally launched ERCS Legal Limited, which is our law centre, meaning we'll be able to take on cases directly and represent both ourselves and other clients in court to advance strategic litigation to tackle systemic issues within Scotland. So, what is environmental justice? I saw there's someone from Friends of St. Fittick's Park in the chat, so they'll probably recognize this picture. This is um, St. Fittick's Park, one of the last accessible green space in Torry, which is a working class neighbourhood in Aberdeen, and which is under threat from development for an energy transition zone. And we hear a lot about just transition in Scotland and ensuring that there's a fair, equitable transition away from fossil fuels. But I think what this image illustrates is an unjust transition where actually the people being asked to shoulder the burden for the energy transition are communities who've already had to deal with neglect and deprivation over several decades, and face losing this park, which includes an award-winning wetland and is well used for leisure and recreational purposes by the local community. They risk losing that for industrial development, being led by the same oil and gas companies who got us into the climate crisis, who are now claiming to champion different technologies to get us out of it. So I think what this illustrates is the uneven distribution of environmental benefits and burdens. And so there's a concept of sacrifice zones that we see where certain communities are often expected to shoulder the burden. And I think Torry is another example of that in different ways because it's also hosting an incinerator very close to a local primary school. Also sewage treatment works, refuse dumps. So, this one community has much greater exposure to potential environmental harms and impacts on quality of life than, more affluent neighborhoods in Scotland. And environmental justice is also about participation in environmental decision making and the ability to meaningfully have a voice when it comes to environmental decisions that affect us. And I'm going to talk about that in more detail in later slides. But it's also about upholding our right to a healthy environment, which is something that we're campaigning for in Scotland as part of a new human rights bill. We think that if we had a dedicated right to a healthy environment enshrined in law, then we would be able to much more effectively uh, enforce our environmental rights and ensure that places that matter to our communities are fully protected. And just to give a bit more detail on this, so there's different types of environmental problems that we might encounter in Scotland. So air and water, noise pollution, proximity to derelict land, issues around environmental quality, and this often affects different communities in different ways. So, for example, gypsy traveller communities often end up in much closer proximity to contaminated or derelict land, face struggles to find adequate sites for living on. But then there's also other impacts which are differentiated on different people. So children and older people, people with pre-existing health conditions are often more exposed to air pollution, for example. People with asthma might be more impacted in that sense. And as I said, yeah, these impacts can be worse for marginalized groups and increase their vulnerability to different events. So this is what we talk about when we're talking about distributional environmental injustice. And this image is of a girl, Ella Dukisi Deborah, who died tragically in 2013, and she was the first person who had air pollution as a causal link to her death when she died of asthma in 2013. And then we also have other issues which are specifically impacting us in Scotland. So people know, I'm sure, about issues around sewage pollution in England and Wales, especially hitting the headlines with the privatized water companies there. But we also have major issues even in Scotland, where there's a lack of monitoring of sewer overflows, and we have a lot of aging Victorian infrastructure, which means that we have a lot of uh, raw sewage being discharged directly into our waterways, and this is something that ERCS is campaigning on. If you're interested in that, you can have a look at the Clean Up Scotland sewage campaign on our website. And so, yeah, this is all about what I mentioned earlier, which is the need to recognize a human right to a healthy environment. And that includes two different components. The first is a substantive component of these six interdependent features: clean air, a safe climate, access to safe water and sanitation, and so on. And this is entirely new if it comes into force in Scots law because it's currently unprotected in our current legal framework. The second part is around the procedural environmental rights that we do already have recognized but are not fully implemented in legal system here. And that includes our right to access environmental information, to participate in environmental decision making, and to access justice on environmental matters and have effective legal remedies. And this is all enshrined in something known as the Aarhus Convention, which protects and sets out our procedural environmental rights. So there's these three components that I just mentioned, and this is something that the UK ratified back in 2005. Yet, for many, many years now, basically Scotland has never actually um, fully implemented the convention because we've been in breach of this third pillar of access to justice, and we have a number of issues around barriers to justice, which prevent people using the court system to uphold environmental law and enforce environmental law. And this is a major issue that we're working on, which needs to change if we're to effectively have access to legal redress and mechanisms to protect the environment. So what are these barriers to justice? There's a few different ones I'd like to go into. Firstly, I think this won't be a surprise to many of you, but it's incredibly difficult to hold the government and to hold companies who might be polluting uh, our environment to account in a court of law. And that's because our legal system is complicated, intimidating, and expensive. I don't know if any of you have tried to launch a judicial review yourselves. I know there's a lot of people from community groups here, but legal costs can often amount to tens of thousands or even hundreds of thousands of pounds. And we have, an arcane legal system which is incredibly intimidating and daunting if you haven't engaged with it previously. And we've seen almost no progress in improving access to justice on environmental matters. I should probably actually update the slide because in the last few days, there has been some tentative signs of progress in terms of overhauling the system we have in terms of court costs to reduce court costs. And I think after some sustained pressure from ERCS and other organizations, we've seen some signs that that may be changing. But it's taken far too long, as I mentioned, ever since this convention was ratified in 2005. We've had ongoing issues around breaches of the access to justice requirements of the convention. And you can see this image here is a protest that we organized to coincide with the October 2024 deadline, which was meant to mark the deadline for when the Scottish Government should have fully implemented recommendations to guarantee access to justice. And unfortunately, we're still waiting for many of those changes to take effect. So legal expenses remain prohibitively expenses, and yeah, you can often find that if you take a case to court, that you're liable to pay your opponent's fees if you lose the case, which is obviously a huge barrier to people even taking that step forward to launch a court case in the first place, because the risk of that is just too high unless you have a lot of financial security. And while there are some mechanisms to cap court costs, these are known as protective expenses orders. These have often been deemed arbitrary and unfair. And yeah, that can be um, varied through what the language is on causes shown, which is obviously quite ambiguous language and doesn't give much legal certainty to people who might be considering taking a judicial review or a case to court. So what we need to do is overhaul these court costs and also replace what's known as the loser pays rule, with a much fairer system so that people feel able to take cases to court if they have the grounds to do so without the risk of bankruptcy or losing all of their savings. And so there's a number of different policy reforms and law reforms that we could make, which could improve access to justice and secure our environmental rights. These are all outlined in ERCS's advocacy manifesto, which we published in September last year to coincide with new elections coming up. And this outlines the comprehensive steps that we could be taking in Scotland, which could help to increase access to environmental justice and bring about a much fairer, more equitable system. So, as I touched upon at the beginning, a legally enforceable right to a healthy environment, which we could use to challenge public bodies and polluters, would be a game changer in empowering communities and enabling them to exercise their own environmental rights and to protect the nature and like green spaces in communities where they live. We need affordable access to justice so that everyone can use the legal system to stand up for nature and um, tackle environmental inequalities. We need fair access to justice through an equal right of appeal in the planning system, which Claire will talk about in more detail after me, and I'm also going to touch on after this. And we need full access to justice through a dedicated Scottish Environment Court. So, affordable access to justice, that refers to the Aarhus Convention and this ongoing breach that we have of Article 9 of the Convention. So, under the Aarhus Convention, access to justice should be fair, equitable, timely, and not prohibitively expensive. And as I mentioned, the cost of going to court currently is just exorbitant and real deterrent for many people going to use legal mechanisms to challenge breaches of environmental law. So we should be increasing legal aid, and there's specifically Regulation 15 of the Civil Legal Aid regulations, which could be broadened to enable people with a joint interest to access legal aid, and that specifically relates to environmental cases because it's very rare that an environmental problem impacts only one person. Obviously, if you think of an issue around uh, a development which is going to impact on a community forest, for example, or um, air pollution that's going to impact a whole community. So accessing legal aid can be really significant in terms of enabling people to take a legal case forward. I also mentioned already the need to reduce court costs, and there's a particular system that we think would be preferable. It's a bit technical, but it's called qualified one-way cost shifting, and it's what they use in personal injury claims, which would replace this loser pays rule and mean that um, people taking a case forward in court wouldn't be at risk of having to pay their opponent's fees if they lose the case, and they'd have a lot more security in terms of taking a case forward, knowing that their costs would be limited. We need fair access to justice in the legal system, and that's about the planning system in particular, which Claire will talk about. But currently, if a community wants to challenge a planning decision, they don't have the right to do so. Only developers have the right to appeal a planning decision by a local authority. And so obviously that creates massive inequality in the planning system. And it's the product of that is an uneven playing field where the people most impacted by planning decisions are unable to have their voices heard. And we've been we at the Environmental Rights Centre submitted a joint complaint with Planning Democracy to the Aarhus Convention Compliance Committee, alleging that the lack of equal appeal rights in Scotland is in breach of the Aarhus Convention. And we highlighted the precedent set by ruling in Northern Ireland, where the absence of an equal right of appeal was already found to be in breach of the Aarhus Convention. So we're still awaiting the outcome of that representation that we put forward, but I think it illustrates that there are real areas in our planning system which are really ripe for reform. And despite some positive changes around the national planning framework, prioritizing climate and nature, the odds are really stacked still in favor of developers when it comes to actually having remedies to address appeal decisions within the planning system. Finally, the third key change we need is a dedicated Scottish Environment Court to process environmental cases. So that would help to increase access to justice and it would provide a full merits review. So currently, if you want to challenge an environmental decision, uh, primarily you can only really do that through judicial review, which is about the way in which a decision was taken rather than the substance of the case itself. So having a dedicated court could enable that, and it could increase access to justice by creating a dedicated forum for environmental cases. It would help to address the fragmented routes to remedy that we currently have in our legal system, where environmental cases are split between sheriff courts, the courts of session, and appeals courts. And yeah, it could create a shop for all environmental cases, which would make the system much simpler and more comprehensible and legible for everyone involved. And it would also help to develop judicial expertise because we know that environmental problems are by their nature very complex, sometimes involving quite a lot of scientific and technical literacy. And by dealing with um, environmental cases day in, day out, we think this would enable judges to develop a lot of environmental literacy and expertise and make much more better informed decisions. And finally, a dedicated environmental court could offer a flexible approach. So there's over 2,000 environmental courts in many just different countries and territories across the world. They combine civil, administrative, and criminal jurisdiction, and they also offer low-cost, flexible ways of resolving disputes, including alternative dispute resolution, which has been used very successfully in Australia and some other territories as well, which reduces the stress of having to proceed with a full legal case if someone has an environmental conflict that they're trying to seek a legal redress for. So, in conclusion, we need to reform legal expenses so that it's affordable to uphold all of our environmental laws. We need a dedicated Scottish Environment Court to cater for the very complex nature of environmental laws in Scotland. We need an enforceable right to a healthy environment with environmental features defined according to the highest standards. So that could be World Health Organization air quality standards, for example, when we're talking about the right to clean air. We also need to undertake more strategic litigation to tackle systemic environmental issues because we know that regulators are often too weak or risk averse in holding public bodies and polluters to account. So while we have for example, some other mechanisms, organizations like Environmental Standards Scotland, which is an environmental watchdog. We find often that they're quite timid in their approach, and there's often a bit of a limitation in terms of the scale of what we've found at ERCS that they've been able to achieve in terms of triggering systemic environmental change to improve environmental quality across Scotland. So we want to see much more systemic changes which can deliver real long-term progress on tackling the climate and nature emergency and empowering communities to act when it comes to environmental problems. So just to finish off, I wanted to come to a short call to action in terms of what people can do if they want to take action in some of these areas. ERCS have a number of different briefings, reports, and videos that you can access on our website if you want some resources, and especially if you're speaking to candidates in the election and you want to be really briefed and up to date in terms of some of the detail on this. And I think that's a really helpful thing that people can do in the next couple of months is speak to political parties and their representatives, speak to your local candidates, ask them what they're planning to do to broaden access to environmental justice, and ensuring that in the next Scottish Parliament we have a strong majority of MSPs who will take robust action to improve access to environmental justice. Um, Also encourage them to read um, both ERCS's advocacy manifesto, but also the manifesto prepared by Planning Democracy, the work that APRS are doing around the election. Lots of different third sector organizations have very comprehensive policy platforms that they are offering to political parties and which are like ready to go to be introduced into law. And it's really critical that some of these policies are taken up because ultimately we have to have our representatives in Parliament taking these issues seriously and listening to the experts. And then, yeah, finally, if you want to support the work that ERCS are doing, you can support our crowdfunder for a new environmental law centre that I mentioned earlier, so that we can take cases to court to challenge government and polluters and secure systemic environmental changes in Scotland. That's all I have to say, and I'm going to pass over now to Claire from Planning Democracy to talk in a bit more detail about the work that they've been doing. But I'm happy to answer any questions at the end of the session. Thanks very much.
Now, can I just pop in there to say, please do type any questions you've got into the chat. We should have enough time at the end for a discussion. So, but it's always good to know what's the kind of questions people have. We've also got some of the questions that you'd emailed in advance that we'll be able to pass on. And before Claire starts, I'd just like to say that Claire this last week was given a special accolade as Woman of Influence in Planning. So we congratulate Claire because we've thought she's a woman of influence in planning for many years, and we're wondering why she hadn't had it before. I only just found it out it existed. So well done, Claire, and over to you.
Yes, thank you for that. And I think basically there's a lot of people working to try to influence planning. And I guess one of the beauties of planning democracy is we work together with those people. And boy, we could do with all the influence we can muster, I think. Moving on. I'm going to share my slides. I've had a few connection problems this evening, so I'm just going to hopefully share my slides. And if it doesn't work, please do let me know. How is that looking?
Well, it's not appeared yet, but we know that it just takes its time because of your connection. There we are, it's appeared.
Okay. Sorry, it might be a bit behind on that. Does that look good? Is that? Yeah, good. Okay. I want to introduce our planning manifesto today and explain why it's important for environmental justice. I've given you the URLs to access it, but we will, of course, send it to everybody after the webinar. And we do have paper copies as well. Um, so, as it says in the beginning of the manifesto, despite its importance, planning in Scotland is really failing the people and places it should serve, as the chat readily demonstrates. Planning decisions have long-term impacts, and decisions today are locking us into not only a unsustainable future but an unjust future as well. And I think there is an opportunity here for Scotland to become a leader in democratic, sustainable, and just planning. We have got strong traditions of community organising, environmental protection, social justice that really do provide some foundations for transformational change. And what we've tried to do with our manifesto is to provide a roadmap for creating a planning system that serves Scotland's people and places. But we feel that real change is only going to come if you look broader than the planning system at other systems, our democratic systems, our land use systems, and so on. So we've tried to do that and produce quite a comprehensive document for change. And we feel that picking off individual actions isn't going to do it. We need a whole systems change, and that's what we've tried to produce. And this has kind of emerged from years of community-led research, and that's brought us into contact with very diverse voices from all over Scotland. And when we were more recently trying to make sure that we included all the issues, we did go to some groups. Some groups we're not able to reach. For example, Gypsy Traveller groups. We went to Making Rights Real, who already work with those groups, and we asked them to help us, identify some of the issues that they see as problematic with the planning system. So we have tried to be as comprehensive as we can about the document. But the background research that we did, oh, sorry, there's some nice photos. There you go. The background, I've focused on the really boring slide now. The background research we did on the manifesto was to think about the way planning is currently approached and what was this kind of fundamental, the underlying cause of the problems. And Scotland and other systems, not just Scotland, but has a system of very growth dependent planning, where the primary goal is not to necessarily deliver development that is needed, but the goal is to stimulate economic growth, mainly through market-led development. And this is a model of planning that relies on private sector development to fund public goods such as affordable housing, your parks, your infrastructure such as schools, and other environmental benefits. And some people I've spoken to, say, well, surely everyone eventually benefits if we boost economic growth. However, this is a model that does create injustices for a number of reasons. And these are that, it often forces planners to prioritize economic profitability over social equity. It leads to weak and ineffective planning. And it means that, priorities such as profits for big housing developers overcome the need for provision of affordable housing. So this growth dependent model really relies on private developers to fund public infrastructure through developer contributions, such as Section 75 agreements. So, for example, when a developer builds luxury housing, the council often requires them to provide contributions of either money or land for affordable housing, school upgrades, or better roads, or whatever. But the flaw in this is that these contributions are legally agreed during the planning phase and are often directly tied to expected profitability of the project. But if economic growth slows, the planning system that relies on these contributions fails to deliver the affordable housing because the projects just become unviable if they have to pay off these Section 75 agreements. So the wider community loses out. And these growth dependent models are often more likely to prioritize development that will violate ecological limits because they are built on the fundamental assumption that continuous economic growth, measured by gross domestic product, is necessary for economic and social stability. And this approach treats natural resources as unlimited, and the environment as often as a sink for waste. And it fails to take into account the physical limits of the planet. And of course, this has an intergenerational injustice angle because it prioritizes short-term economic gains over the long-term survival and well-being of the majority of us and our planet. And finally, this it also creates power imbalances and procedural injustices. It means that private developers take precedence over communities, and it weakens the influence of communities in shaping their own environments, particularly in marginalised groups. So our manifesto conceives of this as a democratic problem, and solving it requires putting communities back at the centre of planning. So we're arguing for a planning system where communities are considered the first parties, the decision makers, the land stewards, and not the third parties as they're currently called. We feel that developers should be the third parties, acting as contractors or service providers for the communities. And this flips that traditional top-down profit-driven model into one that is community-led and needs-driven. So we've put forward a number of issues and a lot of possible ideas. We've got 32 kind of asks in our manifesto, but we've divided them into different chapter headings, and those are the chapter headings we've got. I'm not going to focus on them all because it takes too long. But the democracy chapter we have, which we call "Put Power Where It Belongs," and in this chapter, we really try to move away from the idea that the system is passively reacting to private proposals and instead focus on much more proactive planning in the public interest. And essentially, this means working out ways to enable communities to work alongside local authorities as equal partners in shaping and implementing and monitoring local development plans and the national plans, such as National Planning Framework 4, but also to give local place plans greater weight in decision making. And once these plans are democratically decided, maybe some people might like to call it co-produced, developers should be held to account, with planning authorities being empowered to reject proposals that contradict these agreed priorities or whether they exceed ecological and infrastructure limits. And in that chapter, we also wanted to reflect the views regarding the local governance review, or some people call it Democracy Matters. And this is talking about Scotland adopting a much more democratic municipalism, which is bringing local government closer to communities so that citizens have a much more active role in shaping their towns, cities, and neighbourhoods. And the aim is to shift that power from the central state, which we have a very centralised planning system in Scotland, much more down to community level, and decision making at a municipal level. So how is this possible? How do we actually do this? Well, in other European countries, nationally significant infrastructure projects are subject to significant and well-resourced public deliberative exercises, such as citizens' assemblies. And Scotland's held a number of citizens' assemblies, climate assemblies, and so on. And so these processes involve the public in shaping decisions that requires a much more principles-led approach, but it also requires communities to sort of interrogate the trade-offs and think about, how do you deliver development in the public good on a national basis, and that builds public understanding, and it really helps shape the way things are done at a much more national level. So that's some examples that in countries like France, for example, and we want to sort of look at developing that a lot more in Scotland. Other things we've got in that chapter is establishing community liaison panels that help guide plan preparation. And this is a very practical way to embed local voices and lived experiences into planning decisions. So a community liaison panel have members of the community on it, and they can share their views by taking part in workshops and reviewing draft plans, and co-designing consultations. So it's a much more close working relationship, offering local knowledge through site visits and doing place audits and so on. And these panels can make formal recommendations and participate much more closely in discussions directly with planners and elected officials. And another idea that we've got is to make local place plans part of the statutory development plan. Now, the 2019 Planning Act, that legislation, didn't give communities the level playing fields they were asking for. They weren't given equal rights of appeal, but it gave communities the right, in inverted commas, to compile their own local place plan. Of course, this is in your own time and often at your own expense, with very little control over that plan. So we know that a lot of communities have done local place plans, but how this is actually empowered communities is yet unclear, whether or not they affect the local development plan, or whether planning decisions are made in accordance with those local place plans has yet to be reviewed. But there will be a review of local place plans in July. And it's really important that this review, which will be conducted by the central government, considers the justice angle of whether or not these plans have really empowered communities. Have they helped deliver the right kinds of development? And we want to ensure that that review does look at the broadest sense of outcomes of local place plans. We don't want them just to say yes, we've had a lot of them done and they've been well resourced. We want to know what the actual outcome is going to be. So you can help do this. You can, if you've done your own local place plan, you can write your own review of what that process was like and whether it's made any difference to your, how you feel empowered and whether it is delivering environmental justice in your area. We also got a chapter on the housing, because we feel it's really important that everyone has affordable and decent housing in Scotland. And we know that there's a housing emergency. Nearly 250,000 people are currently on the waiting list for a social home. And meanwhile, house prices have trebled in the past 20 years. And many people believe that the housing crisis is just about a shortage of houses. And if we free up more land, developers will build more homes and the prices will fall and the housing emergency will go away. But the evidence shows that this is not the case. However much the house builders try to persuade us that it is in the interests of their industry to end the housing emergency, it is not in their interests. They would like to pretend that it is in their interest to build their way out of a housing emergency, but it's not. And we feel that there's much better ways to deliver housing than just getting more private sector housing. So we've written about some of those things in our housing chapter, which involves proactively developing housing for land for housing, and that's identifying suitable land in advance through the local development plan, and ensuring that the right sites are built out rather than leaving all the delivery to the speculative industry, which is what we're doing at the moment. So we allow the local authorities to assemble and buy that land strategically, and then parcel that land out for delivery by developers that are interested in doing the development where it is needed, not where they can make a fast buck. And then finally, we've got 6 chapters, as you know, but we're just picking out these 3 chapters. And this is the protecting rights, the justice for people, which seemed like a good chapter to be talking about tonight. And in this chapter, we have identified 3 key things: legally recognising the right to a healthy environment, which Benji has already talked about, and yeah, there's hopefully there'll be an upcoming human rights bill that we can tap into and work to try to deliver that with the likes of ERCS. If maybe if the current administration gets in again, that might be something that could happen. But we also want to bump up our campaign for an equal right of appeal for communities. Following the local place plan review, we will see what that brings and whether or not communities are really given more rights by being front-loaded at the beginning of the planning process and given all those rights to develop their local place plans. If not, we want to reiterate our call for an equal right of appeal at the business end of the planning process, and to grant communities the same appeal rights as developers, particularly when developments contradict local development plans or local place plans. So we shall be keep an eye on our website because we will be gearing up for much more work to be done on that. It's 7 years since we last called for it. That with the Aarhus complaint results, hopefully they will go in our favour, and we can really put pressure on the government to deliver communities the rights, and that should really help with the power imbalance at the moment. And I think somebody was saying in the chat, if they do have those kind of incentives to make the right decision because communities can appeal it, then I think that could really be a game changer. So that's going to be a key campaign. And finally, improving cultural awareness in planning. Is something that the Making Rights Real definitely wanted included in our plan as well. And so training to reduce discrimination and ensure planning decisions reflect the diverse needs of all communities. And I think we often get one particular type of community coming to us. And it's some communities do not know about us and do not directly make contact. We really have to make sure that we're speaking on their behalf as well. So I think that was all I was going to say, except I just wanted to point out that community SOGs have done their judicial review and to try to protect ancient woodland from development. They were unsuccessful, and I would just ask that people just dig in their pockets to help them with their costs, because that's two people have largely been responsible for paying it out of their own pockets, and that should just not happen. So please share that web address widely and encourage people to donate to that. Right, I'll stop there for now.
Thank you so much, Claire. I think both of you have given us a really clear view, firstly, of what's going wrong, but most importantly, what can be done to change it for the better. And I think at the moment, people really are looking for that sort of hope of how do we make things better. Some kind of things that you've laid out there actually would be achievable quite quickly without a huge amount of costs, because that's obviously what governments are worried about at the moment. And also the one thing that really made me think was a lot of the things that you're saying actually appeal right across the political spectrum. It's not something that is particularly one party or another that might support these things. That it feels to me that there are bits that would be supported by all parts of the political spectrum. And I was wondering whether you've got any feedback on how some of your suggestions have been received by politicians or other decision makers. Do you want to start, Benji? Have you had feedback from politicians and government around your suggestions?
Yeah, thanks, Kat. It's a very good question. And I think it's important to acknowledge that there has been support from members of all different parties for the ideas that we've been proposing. And I think what we find is that actually when politicians actually engage more substantively with the detail of what we're talking about, and rather than sort of a caricature of what our positions are, then they do tend to be more sympathetic. So at ERCS, we've given evidence and oral testimony to both the Net Zero Committee and the Equality, Human Rights, Civil Justice Committee, with regards to the Aarhus Convention and access to justice. And I think the culmination of those efforts, which was, over a sustained period of time, trying to engage with members of those committees, was back in April, we had the first parliamentary debate on the Aarhus Convention and access to environmental justice, which was jointly sponsored by those two committees. And it was really heartening to hear members of all parties speaking out in favour of the different policy proposals, was that whether that was to do with needing an environmental court or around legal aid. Obviously, I think maybe more muted from the SNP, given that they're in government and kind of reluctant to deviate from their agenda. But there have been still some positive changes that they've made in terms of removing court fees from the Court of Session for Aarhus cases, for example. And I think that, yeah, sometimes there's obviously going to be different tendencies within political parties. And I think there's sometimes a bit of also, especially within planning, this false dichotomy between, uh, you know, wanting to have like very fast infrastructural changes in the energy system to tackle the climate emergency, which of course, is true in terms of needing to decarbonize very rapidly. Um, but then also using that to basically steamroll any development forward and not actually going through like equitable processes, giving communities a voice, ensuring that proper environmental impact assessment take place. And so I think it is really important that communities do have the option of that to participate in decision making. And I think there is growing recognition from all parties there, but still more to be done.
That's great. Claire, have you got things to add about how your suggestions have been received? Perhaps even the last time round you did the the Equal Right of Appeal campaign.
Yes, it was interesting. We had the Scottish Community Alliance had an all-day event at the Scottish Parliament, and it culminated in a Q&A with members of four of the parties. And actually, Suzanne from the SOGS campaign said, about their campaign and how they had um, they wanted an equal right of appeal, and each and every one of them was sympathetic to that. Yes, but you say, well, you were sympathetic, but what happens when your party all votes together for the legislation? But I would say that some of the things in our so I would say when you are if you are going to lobby your MSPs for the before the election, or you're going to interrogate and look at what their voting preferences are and so on. It is worth looking back and seeing what they have done before, because they very easily hoodwink people, and they will say, yes, I support that, I support that. But you need to sort of do your homework a little bit and look back at their history. But I would say that some of the things in our manifesto, they're not that so out there. The Scottish Land Commission, for example, they really support a lot of what we're saying. They're saying pretty much what we're saying on the housing stuff and the land assembly and so on. So that that has got some sort of political support. There is cross-party support for things like land value tax and things like that. So it's just actually nailing it and getting it through, stopping those lobbyists. So I think it's really important that we are lobbyists as well. And I know we feel weak and small, and our voice isn't heard, but actually I think it does make a difference. I have seen it, when we first started that Equal Rights of Appeal campaign, and that we were told that Equal Rights of Appeal was off the table. It was not going to be considered in the 2019, Planning Act. And we, as the community, very much put it on the table. And there was three amendments from three different parties on Equal Rights of Appeal. So you can have that effect if we all push and we all shout and we all say our priority is justice, our priority is the environment. And I think that's so important to say it and lobby for it so that they hear it.
Thank you, Claire. I think that's very eloquently said. I've got a few questions that were emailed in. One of them was about where the Ecocide bill fits into planning or MPF4. Are there connections there? I don't know, Claire, is that something you've thought about?
I think that ERCS have been done quite a lot on the Ecocide bill, so I won't mention that. But I would say that there's, the MPF4 is policy, and the Ecocide bill is legislation. But both of them need resources. Both of them need to be, well resourced and well monitored and enforced. And there's no point in having legislation unless it's got a budget attached to it, and that you can really drive force through that legislation and make sure it's strong legislation as well. And I think this is what we're seeing with MPF4, is there's not the resources, there's not the political will behind it. It's being sort of whittled down every time the chief planner writes a letter, or they do a review of MPF4 and they're thinking, oh no, the housing emergency is more important, or green ports are more important, and so things get whittled down. So that's really important, I think.
Benji, do you want to say something about the East Side Bill if you've been connected with that?
Yeah, sure. So we've been working with Monica Lennon, the Labour MSP, who's been bringing forward this members' bill to criminalise ecocide in Scots law. And we've been on the expert advisory group for that bill. I think just to briefly touch on what the purpose of the ecocide bill is and what the limitations are of it. So this is very much ecocide, which is within the devolved powers of the Scottish government. So it's only about, what happens within a Scottish jurisdiction. And I think because a lot of the debate around ecocide has been around kind of transnational um, criminalization of ecocide at the Rome Statutes, it's important to clarify that in terms of what we're looking at. But also, ecocides as a proposed law is quite distinct. It's about kind of criminal liability for only the most serious and extensive forms of environmental harm and destruction. So a lot of the environmental harm that we see in Scotland, and in terms of what, say, a specific development, which might cause some localized destruction to like a local native woodland, for example, that wouldn't necessarily be captured within ecocides because the thresholds for criminal liability would be quite high. So we would see ecocide really as the top of the regulatory pyramid. And I think, as Claire touched on already, there are many other existing environmental laws, policies, and regulations that we have to protect the environment, habitat regulations, for example, which, we just need much more uh, effective enforcement of our existing environmental laws. And yeah, Claire also talked about resourcing and budget. And I think, yeah, SEPA, our Environmental Protection Agency, they've had uh, lost 25% of their budget since 2010. So, in terms of the capacity of public authorities to monitor and effectively enforce um, environmental law, that's something really important. I guess with ecocide, one significant um, impact it would have if it's brought into force would be as a deterrent, and that's a lot of the thinking behind introducing ecocide is that it should have a deterrent effect for the most significant harm. So it's proposing prison sentences of up to 20 years, for example, for senior officials, directors of companies who commit ecocide. But obviously, it would be very hard to prove culpability and reach that threshold. So it is could be significant, but yeah, really is one part of the much broader environmental governance regime that we already have in Scotland. Kat, you're on mute.
Here we are. Sorry about that. Just as usual, just as usual. I'm trying to switch between the screen that has the questions on. So we've had a question from someone called Zowie. I think that's how you would pronounce it, but it's difficult to tell, and I'm embarrassed if I pronounce it wrong. About this is probably one for Claire. You've already spoken about it, but how do we ensure centering diverse perspectives when it comes to environmental justice? And you said there's sometimes a challenge for that because of the kinds of people who approach you. And how would you suggest that we make sure we get those diverse perspectives involved?
Thanks. Yeah, well, I think there's two elements to that perhaps. One is ensuring that you try and get as many diverse voices heard while you were sort of co-producing your document, and being open to hearing more voices all the time. So ours is a living document. So I think sometimes it's easier for people to comment on a document once it's written and critique it than to do this sort of blue sky thinking. It's we've tried to make it as simple as possible to sort of help people envision the system as a whole, and hopefully that will help people who are less familiar with the system and less used to sort of talking in that kind of language. So it's certainly not easy, but we have been, as I said, working with those people who do work with particularly marginalised communities, because it's no point us parachuting in and asking people. We want them people who have already been working with them and understanding their situations, and helping them speak to us through them, if you see what I mean. So that was, that's the way you co-produce a document. But there's also what you put in that document, and making sure that it's got you know, that the system works for everybody. And I always think that, if the system is not working for the most the least deprived of people, then it certainly won't be working for the people who are most deprived. So and I think that's the situation that we have at the moment. So it's making sure that some of those policies that are challenging those environmental and those injustices that are inherent in planning at the moment, and that's what we're trying to do.
Thank you, Claire, and thank you for your championing of that as well. Um, so there's a few questions that I'm going to bring together around process and procedure. So we've one from David around kind of talking about public local inquiries being quite a kind of high level legal arguing, and is there a room for some sort of level below that would be a bit more effective? We've got one from Susan Smith around how is there a way to overcome the fact that often parties are whipped to make decisions along a party line? For example, she gives Aberdeen and the local development plan. And then there was another about the appeal system, whereby the decision, or rather the recommendation, is made by one person. And has anyone suggested that that should be changed to more people to make those sort of decisions or recommendations? Or would you be able to sort of talk a little bit about those kind of processy things? I don't know whether it's better to ask Benji or Claire. How do you feel, Benji?
I think maybe actually if Claire comes in first, I feel a lot of those are quite more within her realm of expertise. But I'm happy to come in after that.
Yeah, thanks for that. Yeah, no, David, I really like your idea about the tribunals. I completely concur. Public local inquiries can be just as bad as, just like being in court. And I don't know if maybe you're speaking from personal experience. I suspect you might be. And sorry that you are the token bloke. Are you really the token bloke in the audience? So
We've got Alex and we got Benji.
um, so yes, I would absolutely agree that we would need something. We need something more sort of tribunally, and people have talked about the land tribunal in the past as being an example of this. I've never experienced that myself, and if anybody's got experiences, I'd be really interested in hearing about that, because I suppose it links in a bit to Kirsty's question. Is who do you take these decisions to? If communities do have rights of appeal, how are you going to do those appeals? And how, are they going to have to pay for them as developers now do? Hurrah! A lot, at least they have to pay for them now. That's a relatively new introduction, but that's a welcome thing. But at the moment, we're not quite there in terms of even getting the concept over and persuading people. But I think it's well worth thinking about it, because one of the reasons thrown at us all the time is that it'll clog up the system, and the reporters will be overwhelmed with work. As they are on the short-term lets appeals, actually. So it's not communities that clog up the system, it's the businesses, really. So I think we would have to think and design a system that is perhaps a little fairer and doesn't rely on one government reporter. So maybe more like a local review body type process, but perhaps there's some challenges with those as well. So yeah, I really agree that the way we do these procedures is really crucial.
Do you have anything to add to that, Benji?
Yeah, I think on the tribunal point, so historically ERCS has advocated for an environmental court or tribunal. We didn't really take a position in terms of our preference on that. Uh, More recently, we've tended to use the language of a court, but I think there's lots of different models about how that could operate. And I think, yeah, our vision is of, as I said, a sort of one-stop shop which could be suitable for a whole range of different types of cases and, yeah, remove some of um, the barriers that people might encounter, not only financial, but also in terms of like institutional barriers to go into a court and feeling like, they necessarily had a case which was of that gravity that it needed to go to that level. And as I mentioned, so some of the courts and tribunals around the world which focus on environmental cases do have much more flexible, cheaper, faster dispute resolution mechanisms, like alternative dispute resolution, which can uh, make it much more straightforward for people who want to challenge or decision, whether that's in planning or around environmental law enforcement. And again, yeah, I think having like a dedicated arena where all of these cases could be heard in one place would hopefully simplify the system and mean that regardless of what it's eventually called, it kind of enables much more accessible route for people to take forward and without having to navigate a lot of these quite complex different institutions and um, kind of understand all of the different terminology around, yeah, how different uh, parts of the sort of legal jigsaw fit together.
Thanks, Benji. So we've got a question that came in on the email that was about the role of Environmental Standards Scotland, and I know that you, Benji, have engaged with them on a few things. You've written a really useful report, which hopefully someone can put into the chat and we can send it out. But would you be able to explain a bit about? First, you should explain who they are and also where you think they could have a role.
Yeah, of course. So, first of all, for anyone who doesn't know, Environmental Standards Scotland is Scotland's post-Brexit environmental watchdog. So they were established under the Continuity Act in 2021 as a public body to ensure that other public authorities comply with environmental law and that environmental law is effective. And they were meant to be filling these enforcement gaps that arose in environmental law post-Brexit, taking over from the European Commission after we lost that oversight in terms of how our laws were being interpreted and enforced. And Environmental Stand Scotland, they do have some powers. So they conduct investigations and they can issue improvement reports, which compel public bodies, to implement specific changes to improve their practices. But there are limitations. They only have a remit to examine systemic environmental issues, so they can't look at individual cases. But they are a really useful public body to know about because you can submit a representation to them if there's a specific complaint you have around an environmental problem in your community. And ERCS can also support people to take forward a representation with them. So we've supported a number of advice clients, so people from different communities around Scotland to take forward cases, whether that's on um, yeah, uh, the conduct of specific public bodies failing to follow due process like Scottish Forestry, or whether that's around the failure of um, the Scottish Environmental Protection Agency to fully enforce licenses for pollution in waterways. So I think they can be a useful first port of call. And obviously, there's much lower barrier to entry speaking with them than proceeding with a full legal case. But I do also have to be quite frank that in our experience at ERCS, we've put in a number of different representations on many different issues to ESS, notifying them about breaches of environmental law that we've identified. And overall, we've been quite frustrated with how effective that they've been in providing a serious remedy. So if people are interested, we produced a report summarizing our experience of our first 11 representations, which highlighted that ESS had first of all point blank refused to investigate a significant proportion of our representations. But there also had been a number of really significant and unreasonable delays in how they'd handled some of our representations. Sometimes it was, yeah, over a year before we actually saw any real changes in terms of activities from their end to rectify the problems that we've been identifying. And we also find that they've been quite reluctant to use their statutory powers to enforce environmental law, so that they do have the power of taking judicial review against the government. But to my knowledge, that power hasn't been used. And despite the many, many different breaches of environmental law that we've observed in the last few years, we've just tended to find overall that some of their decision making has been lacking, and they've failed to engage with some of the legal issues that lie at the heart of several of these representations. So I don't want to discount some of the good work that they do. They've done some really positive work on air quality and acoustic deterrent devices, which impacts kind of fisheries and kind of ocean life. So they're worth reaching out to. But I do think, yes, there's certain limitations that we've encountered, and I hope anyone else who's uh, submitting representations to ESS has more luck than we've had.
Thanks, Benji, for that very measured response. So I mean, it rolls me on to one of the questions that was regarding energy consents unit. Someone was asking about the email link to an energy consents unit, that you're not allowed to email objections anymore. We haven't really got anything to update on that or to say, but I did want to point out to everyone, and I'll put a link for those of you that are working on energy projects. There's a consultation at the moment about where the decision making takes place, whether it's at the moment it's 50 megawatt limit, and if it's below, it goes to your local authority, and above to energy consents unit. Now, we found in our battery storage report then a significant amount of failings for energy consents unit to take note of MPF4. And so that is something that we feel could be taken to the Environmental Standards of Scotland. We know that there's been some a member of the community has made some moves in that direction. We don't know what's going to come of it, but so that there are ways of doing these things. We're going to give that a go. We'll see what happens. But in terms of ECU, we believe that decisions would be far better taken at a local level, where MPF4 can be taken account of and they can become part of the local development plan. Because at the moment, energy consenting, it has no overall spatial plan element, and it can't be tied in with need. It can't be tied in with where the grid is. It can't be tied in with anything, because there's no essential planning to it, even though we're supposed to have a planning system that works um, by a plan first, and then the consents come later. But so I'll put the link in there if anybody is interested in this kind of thing. I'll put that in. But I'm going to move on to another question from which ones have I already asked? Going back. So yes, Pam had asked a question about whether it would make a difference if they people who are taking these appeals had to pay their expenses, or what would, and a sort of more general question was, well, what would incentivize better decision making in the first place, and minimize appeals from developers? Or do you think that developers will always appeal, no matter how tight they think the case is?
Well, I think Kat's written a really good reply, and I think it's quite good to bring some people in. Actually, Kat's also written about her experience with the Land Tribunal as well. I think it's worth just bringing some of the participants in at this stage to discuss their perspective, particularly as you're the ones that are experiencing it on the ground. And what do you think? Would it make a difference to each of your cases if there was a bit more jeopardy for the
Yes,
for
go ahead, Kat, and please let us know what you think.
Yeah, so we had a recent case which we won, luckily. So the developer had appealed on the basis of non-determination, but we have been for about a year trying to get the planning office to take seriously that they were breaching the development that was under consideration was breaching habitat regulations. We got ERCS involved, their legal branch wrote a letter, several letters to the planners, most of which they have ignored. They've kind of fobbed them off. With the Community Council has put complaints in. And then in the committee meeting, the legal officer and the planning officer, but particularly the legal officer for the council, gave completely incorrect advice to the planning committees, to the elected members that were sitting on the planning committee. Now, we had been advised that if they had approved, it would have been grounds for judicial review. Luckily, they refused the developer's appeal, but there was just no engagement whatsoever from the planning department, from the planning officers, from the head of planning at Scottish Borders Council, or from their legal department. And I just feel like if they had, if if they knew, and we had threatened them with judicial review, we didn't have to luckily make that decision, but we had made very strong kind of noises about that's what our next step would be. I just think if they knew that they had to pay their own fees and if they were liable, they would have spent a bit more time engaging with us and actually having a discussion with the community about the legal implications of what they were doing. And they would have had discussions with our lawyers, rather than just fobbing us off and ignoring us. So yeah, that I think a bit of culpability would definitely make them engage more.
Does anybody
There
else
is
have
a
something to
yeah,
add? Sorry.
there is another side to that as well, of course, because the SOGS campaign in Vergordon, they were
Yeah.
threatening judicial review, and still the planning department, they did, make sure that they followed the process. And as long as you follow the process, it doesn't really matter about the outcome, because that's not what the judicial review is about. The
Yeah.
judicial review only looks at the process and not the merits of the decision. So that's it is a deterrent in certain ways, but in others, it's not entirely, I think.
Just in the last 10 minutes, would any of the other people on the call like to share a bit of their experience in this area? It's always really helpful to hear from people. I'll have to see if anyone's got their hands up. Oh my gosh, how do you do that? Here we are. Okay, so I can scroll through. In the meantime, while you're thinking, I'm going to ask another question that's come in from the emails. Yeah, so Susan's asked about what can we do if planning conditions aren't adhered to, even by the planners in matters specified in conditions, applications following conditional approval. Do you want, Susan, if you're here, do you want to just explain a little bit about your situation?
Yeah, it's all about, I don't know why it's doing that. Planning permission in principle was granted with 41 conditions. Then came the matters specified in conditions. And one condition was that any MSC application had to name the end users. So the first one came in about the phasing, no end users. The next one was all about moving the East Tullis burn. Again, no end users. And that was perfectly okay. The planners approved them both unconditionally. And we discussed having a judicial review. And I think the answer was it would be we had a very weak case, because people would say, oh, a reasonable person would say that you don't need an end user at this stage. And you got the feeling that the planning officer was doing her very best to make quite sure the development wasn't speculative. But the way it is, it's forging ahead with no end users. So a judicial review is useless, really, because they could follow the same process and come to or a different process, do it properly and come to what can you do?
Claire, is that something you're able to answer? Or possibly we need both of you all the minds.
Yeah, it is really difficult, isn't it? And I'm sure they've already exhausted every opportunity, through enforcement officers and complaints to the rather toothless ombudsman. And there is so little at our disposal to make sure these things happen, and we're left with things like trying to embarrass them, and the public protests, and I know that that campaign's really done a lot of that. So it just the system leaves us so few. It gives us so little to make sure that things are done properly. And it sounds like it was a very poorly written or ill-conceived condition, but perhaps done with the best of intentions, as you were saying, but
Well,
not enforceable, clearly.
there is another one. Condition 980 was they had to have an environmental management plan, and the environmental management plan manager was to be the first point of contact. And so the contact details that have appeared is just a generic one for the developer. So I'm going to write to the compliance department and the planning officer and the councillors. I mean, it's a little thing, but it's really important because the community has got worries already. The place is being trashed. And, so you can think if you're trying to put that in to protect the environment and nobody is sort of could get in touch with people who are on the ground who will know, what's actually happening. And you do it to the developer and then they'll probably go along to somebody else and then it will take a long time.
Claire, I was thinking there's some stuff in your manifesto that speaks to improving the stuff around conditions. Is it worth saying a bit about that? Because you've done some thinking about what would make it better, haven't you?
Yes, well, we have got a section on strengthening and monitoring and enforcement, and talking about closing this implementation gap, and making sure that they're enforceable. Requiring photographic evidence, and providing measurable evidence. But yeah, actually, it would be worth thinking, Susan. How could we prevent your situation from happening, and what could we do?
Exactly, because
Is
there's
there
a whole
some sort of body?
lot more matters of
Yeah,
specification in applications down the line.
yes, yes, and also just, I mean, it comes down to the taking it back to the mitigation hierarchy, and just not conditioning in these the conditions that make a planning application acceptable
Yeah.
to the public, and or notionally so, and a lot of the environmental protection is reliant, or even enhancement is reliant on conditions, rather than them looking at the mitigation hierarchy in the first place, and doing this thing called avoiding the damage in the first place. So yeah, I'll be interested to talk to you, Susan, more about how we could perhaps what can we do more to ensure that your situation doesn't
That would be good, Claire. I don't know if phone would be better because
yeah.
I don't know what's wrong with me at this end.
I'm sure there's nothing wrong with you.
Well, there's two of me.
Yeah. Send me an email, info@planningdemocracy.org.uk, and maybe we'll have a little bit of think about that, see if we need to add something in on our manifesto.
Thanks, Claire.
Right, so I'm going to just draw it to a close now and say thank you so much to Claire and Benji for what they've said. One of the things it's good to point out is that the call for an equal right of appeal is on the manifestos of Planning Democracy and ERCS and APRS. So in terms of something that we feel would make a really big difference, really quite quickly, and is something that is relatively simple thing to talk to people about. It is a good thing to talk to people who come onto your doorstep or when you're in a hustings, because it just is so obvious how unfair it is when it's spelt out. So, if there's just one thing that you've got time to say to somebody, perhaps, it depends what it is that you're personally involved in at the moment, but that might be something that we could try and get across to candidates, to existing MSPs, and then start a campaign again once the new Parliament's in place, where we'll have, we think, 50% of the MSPs will be new. So, who knows what will come out of that? There could be some positive things. So I'll say thank you so much to everybody for coming. We'll send out some links to you. We will send out the recording, and we've got another webinar about data centres, and it's data centres and planning, and that's coming up, I think, on the 25th. Is that right? That's just taken that out of my head. And then also to remind you that if anybody would like to come to a campaign day, it's also our AGM, which will slot into an hour of the day, and the rest will be for campaigners working on planning issues, particularly data centres, but we don't want it just to be for people who are working on data centres. So please consider coming along to that, and thank you so much, everybody. Goodbye.